Welcome Instagram, Facebook, welcome everyone to this live session. Maybe let me end and redo. I forgot to put a title on Instagram. So we're gonna go again. Discard this. Let's go on Instagram again. Let's just put live updates happening in Trumpland. Okay, there you go. Drop the US flag if you can hear me and see me well, please. We're about to get started. I think, okay, we're already on Facebook. I'm not sure if Facebook can see me. It's LinkedIn and YouTube. Please, if you're on those platforms and you can hear me and you're seeing me, please type USA in the chat box. Oh boy, let me start again. Instagram, don't leave. We're rejoining again. Don't leave. I'm sorry, guys. Just a little bit of a challenge here. I'm just reconnecting again to Instagram so we can get started. All right, guys, type USA, USA. Let me make sure you can see me and hear me. Drop the US flag emoji. And then let's jump into the live session now. A second bill, a new bill has been proposed, and we want to start with that. There's a lot to talk about. Another bill, as if you've been following us for a while, you already know, or you already know from elsewhere perhaps what a bill is. A bill is just a proposal, right? A proposal that is made so that the bill can become law. It's a draft in the hopes that it can become law or legislation. So we already have one bill that was proposed in Congress, or introduced in Congress a couple of weeks ago by Maria Salazar, the Dignity Bill. We've discussed the bill extensively right here. We've shared a lot on that bill, and now we have another bill that has been introduced. And you guys know I'm going to tell you everything about the bill, and I will tell you if this bill can pass, because it's supposed to give about 11 million undocumented people legal status if they've been living in the country, in the US, for at least 7 years. I'm going to tell you if this bill will pass is likely to pass at the end of the day. I have a lot to share with you, so stick with us and let's get through this. Okay, so Alex Padilla is the name of the senator who introduced this bill, and he is a Democrat senator, I believe from California. Let me make sure. He is from California. Let's see, he's a senator from California. Yes, he is a senator from the state of California. And guys, guess what? The bill is called the bill focuses on reforming a registry law. And this is the 5th time. Yes, you heard me right. The 5th time. Number 1, number 2, number 3, number 4, number 5. The 5th time that this proposal is coming up in Congress. Do you think that 5th time will do the magic? Will that be the charm? Is that when they're actually going to make this a law or not? Okay, so we're going to be discussing what has happened so far and what we're anticipating, what we're looking forward to next. Okay, so let's talk about the 4 past modern attempts to reform the registry law. First of all, what is the registry law? Okay, I have my screen here. I'm going to share with you. Let me just share this with you first of all. Let's share this here. I think this will be a good starting point. This is a one pager. No, not this. Let's do the one pager now. Let's hold on. Let me share this first. Let's do the initial introduction. Oop, I'm sorry. There you go. Okay. Yeah, let's do this first. This is from Alex Padilla himself, and he talks about the fact that the bill, he announced that he was introducing this bill on July 25th, 2025, and the point of the bill is to expand a pathway for lawful permanent residency for millions of undocumented immigrants in the United States. Okay, now let's move here. So the registry statute of the Immigration and Nationality Act is what he wants to reform. What is the registry statute? Currently, if you've lived in the US since before January 1st, 1972, you can actually apply for a green card through the registry method. And it doesn't matter that you've been undocumented, you didn't enter with inspection, you didn't come with a visa. The registry method allows you to apply for a green card so long as you can establish continuous presence from or prior to January 1st, 1972. So what the senator is trying to do is to bring that date forward or introduce, what he calls a rolling date or a rolling timeline, not any fixed date. Okay, we'll talk some more about that. Bear with me. So currently, if you have been living in the US since before January 1st, 1972, since January 1st, 1972, then you can apply for a green card in the US under that law. He's mentioned that he doesn't think this is modern. He actually cites the fact that since between 2015 and 2019, just about 305 people have been able to apply under this law, meaning it's barely useful to a very large part of the US population. And so he wants there to be an update on the registry part of the Immigration and Nationality Act. I believe it's Section 249 of the Immigration and Nationality Act. And what he wants them to do is that if so long as you've lived in the US for at least 7 years before you file an application, if you don't have a criminal record, you meet other eligibility requirements, then you can receive a green card. Okay, now let's come here. There are other people who are leading the legislation in Senate. We have the Durbin. He's a ranking member of the Senate's judiciary. They, discuss things that have to do with some of the laws in Senate and, drafting those laws when they have to draft some of the laws or, just bring them before the whole Senate. It goes through some of these committees for them to deliberate on. So he's a ranking member of the Senate Judiciary Committee. And Representative Zoe Lofgren, she is a Democrat congresswoman for the state of California. And all the previous 4 times that this bill has been introduced, I'm not counting this 5th time, they've done it together. Alex Padilla along with Lofgren, they've done it together. She's a leading companion of the legislation in the House of Representatives. So Alex Padilla is representing in Senate. Lofgren is representing pushing this legislation in the House of Representatives. Congress is made up of Senate and House of Representatives. Okay. I'm sorry. Okay, so the basis or the reason for introducing this bill is that they wanted to reflect today's reality. They believe that if you pay taxes, you've contributed to the US, your economy, you don't have a criminal record, then you deserve a pathway to legislation. And it's against that backdrop that they're introducing this bill. This is really small. Let me see if I can okay, I don't think I can zoom in. I was trying to zoom in. Okay, then the next thing we talk about is okay, I think we are done here. Let's go on to the next slide. Okay, so since this law, this registry law was implemented or was first codified in 1929, Congress has modified it 4 times. And most recently, the most recent modification they gave or they did was during Reagan's administration. This was in 1986, almost 40 years ago. No changes have been made. So now, if you've been in the US for more than 50 years, then you can apply for a green card, and that not many people are eligible. Okay, cutoff dates for eligibility remains January 1st, 1972, as I mentioned. And so the reform is planning, number one, to amend the existing registry statute by moving the cutoff date from 1st January 1972, and it's going to be transformed into a rolling date so that anybody who has lived in the US for 7 years before they file an application under registry should be granted a green card. Number two, if they have a rolling date, then there's no need for Congress to have to tie it to a specific date, and they don't need to keep changing the date. Okay. Now, I like how Senator Padilla ended his proposal. The one, his when he had the, I believe Congress, or he had a meeting. He hosted the meeting on when he was introducing this bill. What he said was, quite moving. He said that I asked the American people, if you trust us to pick your crops, help build your homes, take care of your children and elderly parents, play with your sons and daughters in the same sport teams, why won't you trust us to be part of the American dream? All right, so that's the question Senator Padilla is asking, and letting America know that. And I listened to him this week where he talks about the fact that the Trump administration is making a big mistake because they seem to think that you cannot follow the rule of law and be compassionate at the same time. And he begs to differ. He said both can be achieved simultaneously, both can be done at the same time. The fact, and again, they're saying that, look, we're not saying don't remove people who are dangerous criminals. You can do that. The people who have not committed any crimes, just allow them to stay here. They are paying taxes and they are useful members of the society. Okay. Now let's move on to now we've understood what the let me just share what the registry, green card through registry process is about. We've already shared the statute on our social media pages, the exact section of law under INA 2459. I probably could pull it up again here. Let's see. I'm going to go now. Hold on, guys. I'm just going to go to okay, that just went back right back to our page. I'm going to go to the section of law that we shared on our social media page. Section INA 249. I don't, okay, no, it was actually the video. It was on the video that we shared that. Okay, no worries. I think I can share it here. But in the meantime, let's take a look at this. This is from the USCIS website when you're applying for green card through registry. And this is one of the things I tell people. Some people are like, oh, I never knew such a law existed. Well, there's a lot of laws you might not know about, which is why it's always good to speak with an attorney, because you might think you know everything about US immigration, but there are certain things or certain laws that may be not very popular or not very common, or that could apply to you, that without speaking with an attorney to find out what you qualify for, you may never know about. So green card through registry has been there since 1929, as you guys know. Now, look here, it says registry is a section of immigration law that enables certain individuals who have been present in the United States since January 1st, 1972. It gives them the ability to apply for a green card, permanent residence, even if they're currently in the US unlawfully, as we said. Now, eligibility criteria, please pay attention. We're going to connect this to Hadila's bill, and there are certain things I'll bring to your attention. Okay, so you may be eligible to receive a green card, permanent residence, under the registry provisions if you meet all of the following conditions. One, you entered the United States prior to January 1st, 1972. Then the second thing is that you have resided in the United States continuously since you entered. Then the third thing is that you are a person of good moral character. Again, without them including this specific one, especially, you see, you'll remember that the bill, or well, we haven't gotten to the bill, but one of the things that Padilla is saying is that if you meet all other current eligibility requirements, it includes being a person of good moral character. And so if you have any criminal records, or you are somebody that falls into trouble, you have issues with law enforcement, then you cannot expect to benefit from this. You cannot expect to benefit from this because you will not be eligible under this law. Okay. The next thing is that you are not ineligible for naturalization, or citizenship through the process of naturalization. In order to be eligible for naturalization, you always also have to show that you are a person of good moral character, you don't have criminal issues, you pay your taxes, you uphold the law, things like that. You're somebody that has resided in the US for a period of time. Pretty much you are just not eligible for, you should not be disqualified from US citizenship through naturalization. All right, then the next thing you will see is that you should not be removable or deportable under Section 237A 4B of the Immigration and Nationality Act. You're not inadmissible under 212A 3E of the Immigration and Nationality Act, or as a criminal, procurer, other immoral person, subversive, violator of the narcotics law, or alien smuggler, bringing people in without authorization. We won't have time to go into these other things, but let's move on quickly and then just jump to the one pager of the law here. So there you go. So this is the summary of the bill. He said, Alex Padilla said, if people have lived in the US for years, if they've paid taxes, contributed to the economy, then they deserve a fair shot at the American dream. He's looking at roughly 11 million undocumented people who would have the ability to live in the US. Then we move on to this. Okay, so we talked about this already. The time this was enacted, and it was updated, the last time it was updated, I should say, in 1986, President Ronald Reagan, he signed into law. It allowed nearly 3 million undocumented people to apply for legal status. Okay, it was already law since 1929, but Reagan updated it, and it allowed 3 million undocumented people to apply. Today, more than 70 years, the cutoff date is people who have been here for at least 50 years. And as you can see, just 305 people have been able to get green cards under this law between 2015 and 2019. Meanwhile, there are millions and millions of undocumented people who try to apply for green cards. Okay. All right. Now let's go here. Let's start looking at the modernization efforts. I'm going to get started here. I'm trying to pull up the current 1972 law. Okay, I've been able to pull it up from in my email hasip. So let me just go here. and then share my screen with you. Let me take this off. Okay, I'm going to share my screen with you, and you'll see the actual law again for those who have not seen it. So, okay, there you go. I hope this is a little clear. Let me zoom in. Okay. All right. So this is it, record of admission for permanent residents in the case of some non-citizens who entered the US before January 1st, 1972. This is section 249 of the Immigration Nationality Act, or 8 USC 1259, okay, section 1259 of 8 US Code. A record of lawful admission for permanent residents may, in the discretion, is a very discretionary analysis, in the discretion of the Attorney General and under such regulations as he may prescribe, be made in the case of any alien, let's jump, once he establishes that he entered the United States prior to January 1st, 1972, he has had residence in the United States continuously since such entry. 3, he's a person of good moral character. 4, he's not ineligible to citizenship. And let's see, and is not deportable under section 1227A4B of this title. Okay, good. So this is the current law as it stands now. He wants to bring the date forward. Well, take off a fixed date, and just make it on a rolling basis. If you've been here for 7 years, you get a green card. Number one, I think that this is, even the dignity bill, I think may stand, in my opinion, a better chance of passing than the way Padilla has couched this. And again, we have the actual text of the bill. It's just 2 pages. Each time they propose it, they make it it's very, very, very short. Unlike Maria Salazar's very detailed bill, I guess Padilla doesn't have time to be over-explaining. He's just, look, you guys want it or you don't. It's a 2-page bill. I'll share that also right here. And then we'll look at the text of the bill. We're going to look at the 4 previous times. This time included makes it about 5 times at least, that this same thing has been introduced and it has not worked in the past. If you guys, those who have been following us long enough, we've discussed this, in our live sessions in 2021. If you remember the same issue, we're going to go over what has happened in the past, and then you guys can determine or decide for yourselves if you think that this stands a chance of becoming law. Okay, so the first attempt at modernizing, in recent years, modernizing or trying to bring the date forward. If you guys again remember, this was in 2021 when President Biden was in power. And when he was in power, he, there was the build back better. What was that? The BBB, build back better, I believe. Is it it was just called the BBB reconciliation draft. And it was pretty much a spending bill, like money bill. And they tried to introduce the Democrats through the House Rules Committee and through House leaders like Lovgren, the co-sponsor of the bill in the House of Representatives. They introduced a registry pathway in the BBB reconciliation draft, but it was not adopted in the final House bill. I remember that that version was struck down by the Senate parliamentarian, McDonnell, the Senate parliamentarian at the time. She struck it down under the Baird rule, where she said that it was pretty much creating new rights, and that could not be allowed because it didn't have enough connection with federal spending. And so under Baird rule, that had to be excluded under parliamentary rules. So that was struck down. They wanted to move the date at the time from 1972 to 2010, so that anybody who had been here in the US since 2010 could get a pathway to lawful status. It didn't work. That didn't work. That was extremely disappointing because we were banking on that a lot. And unfortunately, that in fact that was, I would say, the closest I had come to believing that something was going to be done. I thought that was it. That was a very wonderful, wonderful proposal. Move it from 1972 to 2010, and it was going to give more, millions of people status. It didn't work. Then in July 2022, specifically on July 20th, 2022, the 117th Congress, they introduced the same rep, Zoe Lovegren, she's Congresswoman for California. She proposed this rolling 7-year eligibility date instead of the fixed 1972 cutoff. This one also passed to the House Judiciary Committee. I need to share this screen, this with you guys. Hold on, let me see if I can. Yeah, I wanted to show you guys how the bill stalled in Parliament. Let me see if I can just quickly share the screen here. I believe my team is sharing it. They're going to share it soon on our social media pages. But I just want to be able to show you guys here. It's quite unfortunate. I don't have it on my screen with me, but hold on, I'm pulling it up and I'll show you. You can track the bill. So I went on the Congress website and I tracked all of these various, there are about 4 of them, and all of them stalled. All of them, they didn't get anywhere. Some of them, the same day they arrived, they were dead on arrival. The same registry reform bill we are talking about, the same registry reform bill we are talking about, they got there to Congress and they were literally dead on arrival. They didn't go anywhere. They didn't even see the light of day in Congress. And so, okay, there you go. I've been able to this is the bill. We're not looking for the bill, we're looking for okay, that has arrived now. Let me share it here. Excellent. I'm just going to show you guys one of the things I was able to track. Let's take this off. Okay. Guys, stick with me. We still have a lot to talk about. Okay, please. Okay, let me share right here. Oh, there you go. Okay, I think it's sharing. Okay, there it is. I don't know if, let's see. Okay, good. There. Oop, maybe I should just go back a little. You can still see it. So can you guys see my screen, please? The screen I'm sharing. Let's see here. Let's share it again. I don't think you can see it. Okay, there you go. Now, if you look at what I'm sharing with you, this is one of the bills that was introduced, renewing the same thing, renewing immigration provisions of the Immigration Act of 1929. Okay, now let me go back to the second. So we were done with the first attempt was by, as I mentioned, the Lovegren woman, and it passed. The bill passed to the House Judiciary Committee. It went to the House Judiciary Committee. Then from the House Judiciary Committee, it went to the Immigration Subcommittee on November 1st, 2022, and that's where it died. So July 2022, it just died. November 2022, no further action, and it just expired in Congress or in the House of Representatives on January in January 2023 when the 117th Congress adjourned. Okay. Now let me see. I don't want to show you guys the tracking of all of it. So I just picked one in 2023 that I'll highlight to you. Let's go on to the second attempt. So this is the first attempt. It was HR 8433, July 20th, 2022. It died by November 1st, 2022, pretty much January 2023, it was gone. Then the second attempt of this same, trying to change the registry date was S4974. That's the name of the bill. Senate. This was a Senate companion of the bill that had been introduced in the House of Representatives. They introduced a Senate companion in the House, in the Senate. I'm sorry, in the Senate. There was a House version, there was a Senate version. So the Senate companion was introduced in September 2022, specifically on September 28, 2022. It was introduced by the same Alex Padilla in 2022, effectively same language. What happened was that it was read twice and it was referred to the Committee on the Judiciary same day. And it remained in committee and expired. It just expired at the end of the 117th Congress. Expired just like that. Didn't see the light of day. Okay, I believe this is the one that died like that same day. Nothing even happened after I was introduced. Then the third attempt was HR 1511, 118th Congress. This was in 2023. It was reintroduced, the same bill again, to change the date registry from 1972. It was reintroduced on March 9th, 2023 by our very own Representative Lovegren, the same woman who is currently a co-sponsor of the bill. Same rolling cut-off approach. It was sent to House Judiciary Committee, and then it was referred to the, this was on March 9th, 2023. It was referred to the House Committee on the Judiciary. That's what I think I have here. Okay, no, I have the second one. Okay. It was sent to the Judiciary Committee, and then also nothing happened. Then we have the final attempt before this one, fourth one, S2606, 118th Congress in 2023. This was the Senate version of Lovegren's House of Representatives version in 2023 by our very own Alex Padilla, introduced on 27 July 2023. Very similar time frame as now, because he also introduced this 2 days before, like, so 25th July 2025. He introduced this 27th July 2023. It matched HR 1511's provisions. It was pending in committee. I'm sorry. So the latest action, July 2023, July 27, 2023, it was read twice, referred to the Committee on the Judiciary. Okay. All right, let's come here. Okay, so that's what I have here. This is the one that latest action as of now, July 27, 2023, read twice and referred to the Committee on the Judiciary, and nothing else happened. Nothing else happened. And because nothing else happened, they've reintroduced it, because once the session of Congress ends, then if a bill is not voted upon, then you have to reintroduce it if you are serious about having it passed into law. Okay, so those are the 4 previous attempts that we have had. Attempt number 1 was in 2021, when they included it. Democrats included a registry update in the Build Back Better reconciliation bill. It would have moved the cutoff date from 1972 to 2010. Senate parliamentarian rejected it, as I mentioned, violated reconciliation rules. This was the first serious attempts. That was not a formal bill, but it was just sneaked into the Build Back Better reconciliation bill. They said it was not a spending bill or had to do with money, so it could not be part of that BBB bill. Second and third attempt was in 2022. Both expired in January 2023 without a vote. Fourth and fifth attempt, 118th Congress, also both stalled in committees and expired. Now we have the current attempt, what we have now, 119th Congress, 2025, S4974, reintroduced by Senator Alex Padilla. He continues a rolling 7-year rule, and Obviously, he wants to expand coverage to dreamers, children who came into the US when they were young, give them status CPS holders, essential high skilled workers. Now, guys, one of the challenges that I have found, before we get there, let me go here. Now, let's look at, some of the questions that people have been asking is that are these people just trying to give us fake hope? Because even when Democrats were in power, they did nothing. They didn't, well, what people see as nothing. They may have tried their best, but they didn't come out with too much, right? And now that they are no longer in power, they are trying to get this passed. So in 20, I'm sorry, hold on, let's go back here. Let me see. Now between 2020, well, in 2021, when this happened, or when Biden was in power, Democrats controlled both chambers of Congress and obviously the White House, right? Senate, they had 50 Democrats, and then we have VP Kamala Harris. She was a tiebreaker. House of Representatives, obviously Senate is 100, right? But we had 50 plus. I mean, yeah, the Democrats had 50 plus Kamala Harris. And then House of Representatives, Democrats had 222, and then Republicans, we had 213. So Democrats were the majority. Then even then it didn't work out. Now what's happening in Congress is that it's controlled by the Republicans. You already know. Senate, we have 53 Republicans, 47 Democrats. House of Representatives, we have 230 Republicans, 205 Democrats. President Trump obviously is a Republican, who's controlling the House. Okay, so all right. So here I'm just, just the time that they could have passed it while they had majority, they didn't do it. They said, the Senate parliamentarian said that registry updates was too much of a policy change and it could not go through reconciliation. And so she blocked it even without needing Republican votes. They didn't even vote on it. And okay, let me not go, let's not discuss filibuster here. Now, one of the main challenges that I've seen, or in my opinion, could pose a problem. I mean, we won't even, without even talking about, let me take this off. Now, without even talking about, voting and filibuster, let's go on to the bill itself. I have the one pager, no, not the one pager, the actual law that they want to, the actual law. Let me see if I can take this off. Let me add this, please bear with me. Thank you. Hold on, let's see. Let's look at the actual bill. Like, what is it? What is the writing? What are they saying? What is this man, Padilla, saying in the law? What is he trying to amend? What is going to replace what we currently have? Now, this is the text of the bill, the full thing. Yeah, 2 pages. So he says that he wants to amend Section 249, as we've mentioned. And the title of this is Renewing Immigration Provisions of the Immigration and Nationality Act of 1929 under Section 2 Registry. He says that Section 249 of the Immigration and Nationality Act is amended in the section header by striking entered the United States prior to July 1st, 1924, or January 1st, 1972, which is the current law, January 1st, 1972, and inserting long term. So he wants to replace January 1st, 1972 with a long-term resident of the United States, and 2, by amending subsection A to read as follows. A, enter the United States at least 7 years before the application date. Now, this draft he's done, I think it's quite problematic. I'm not a drafter, but I think it's quite problematic that he wants to transform or replace the fixed cutoff date with a rolling date, right? So if you even enter the US in 2025, then 7 years after, which would be what? Let's test my math. 2032, you can apply for a green card. If you enter the US in 2032, 7 years after, which is 2039, you can apply for a green card. This is a problem because I see it as a pull, like a pull incentive, a pull factor to incentivize undocumented immigration. Now, if you are saying that, oh, let's do it rolling basis. So if you come into the US, if you are here for 7 years, you get status, then people are going to be incentivized to come into the US, stay for 7 years. You know, they come into the US, violate the terms of your status. In 7 years, they're going to get a green card. Then what will be the point of enforcing the nation's immigration system? So I see that the Republicans knocking this down. Like they are not even, because unless there's going to be, or Alex Padilla has another plan where he's going to say in another section of the law that, this law will take effect or would only apply to people who are already in the US as of the time of the execution of the law. If that's the case, then isn't he better off stating that cutoff point as, let's say, it will only apply to people who have been in the US since July 2025? Then we know we have a cutoff point. But to say a rolling basis, like there's never a cutoff point, and so it could apply prospectively to people coming into the US and retroactively to people who have already entered the US. And I really see this as a problem, again, because it's just going to incentivize people to say, okay, then if I can get a green card, if I come into the US after 7 years, then sure, I'll get a B2 visa, come in, overstay, and then try to get a green card. Okay, so they may want to look at that. I don't know if there's a plan in place or he has another interpretation for this rolling basis, but I foresee that being a problem. Oh my gosh, we've already run out of time. Let's see. We've already run out of time. We had a lot to discuss under this bill. Let me see if I can take questions. We had to discuss a bunch of other things. Let me see what we can quickly talk about. You guys, make sure you're following our social media pages. We're trying to keep you updated on what's happening in US immigration law. So make sure you're following. Don't just go watch what's happening and then leave without following. Because if you follow, then once we have the news, we can we can share the news with you and you can keep up to date with everything that is happening. Okay, so birthright citizenship plan has been executed. They've laid down detailed plans. The various federal agencies, USCIS has released its plan. Department of State has released its plan. Social Security has released its plan, and they are planning to deny citizenship to babies whose parents, at least one parent, does not have lawful permanent status in the US. Obviously, the executive order, which intends to end automatic birthright citizenship, is not yet in effect. It's been blocked nationwide through a certified class action. There's nationwide injunction currently in place. So they are just preparing for when the policy takes effect. I think we'll likely do another live session to cover some of those things. We shared some live videos covering them. So that's what's happening with the birthright citizenship order, still blocked, but the agencies, when we were running in school, you were doing track, right? And all the runners were lined up. There was something called, I don't know if it still exists, there was something called on your marks. On your marks. So that you kneel down with you go down with one knee and your fingers are pointed, your fingers are pointed to the ground, and you're waiting for the signal, whether it's a gunshot or the boom or the clap, and then you take off. That's exactly what these agencies are doing. They are on their marks. They've prepared detailed implementation, and they are waiting for this injunction to be lifted, and they say, go, you can start denying US citizenship to babies who are not born to lawful permanent people with lawful permanent status in the US, and they are ready to implement it. For example, Social Security, if you look at the implementation guide, I've reviewed all 3 implementation guides into detail, both, all for USCIS, for Social Security, and for Department of State. And Social Security specifically states on the at the beginning of the guide that it's still being developed. There's still, they're likely to edit some portions of the guide based on operational considerations. So, there are likely going to be changes. And as I always tell you, once something becomes law, it's very hard to just foresee how the law will be applied or implemented across board. There will always be a variety of different factual circumstances that will call into question what one word means, what this means, or whether, okay, sometimes even the law as it stands is very clear on its meaning, or it's very clear, like on the face of it, the law is very clear, but how should it be applied to this person's factual situation? Or how should it not be applied to this person's factual situation? Will this person fall within the exceptions that the law has perhaps particularly carved out or not? So all those type of things will be developed. So you realize that laws get developed more with implementation. It's just like practice makes perfect. When laws are drafted, I would say that they are usually generally more theoretical. They're very theoretical. It's in its implementation in case law that we start to see the practicalization of the laws, okay, with real life situations. And then case law will start to fill in some regulatory gaps that the drafters did not fill in when they were drafting the law, or perhaps did not contemplate when they were drafting the law. Okay, so yeah, I just wanted to pull up the Social Security, memo. I don't know if I don't know why I can't pull it up on this. I just wanted to, oh boy, yeah, I don't have it on this device. But yeah, they said it was still being developed. All right, now guys, let's take some questions. We have some time for questions. Let me see if we have some questions. And we can we can answer them. Let me see on Instagram. Let's see here. Oh, SP Shiv Patel 87 on Instagram says, my priority date is 4th May 2006. DQ is January 2025. F4 category still not received interview. Okay, so let me explain to you that, or to everyone, that there are 2 categories of filing. You have the immediate relative category, then you have the preference immigrant category. Preference immigrant category means that your petitioner, it's I would say a less, or it's a less preferred method of filing, but it's not something you will necessarily choose or you get to choose. It's determined by who your petitioner is, number 1, and number 2, what your relationship is to that petitioner. So for immediate relatives, they are the top priority of U.S. immigration: spouses, parents, and minor children of U.S. citizens. There's no wait time for them to get a visa. Wait times are usually determined by visa backlogs or sometimes just case, backlogs, or particular embassies could have some delays, here and there, but no wait times for those three people. The preference immigrants category, there are wait times. The first wait time is determined by your priority date, which is your place in queue in the immigration line. It's just like going to a restaurant, McDonald's, you get number 25, another person gets number 50. You get your food number 25 earlier than the person number 50 because you come first. Immigration, your priority date is your place in line. So instead of a number 25, your date, the date you submit the application that USCIS receives it, that's your priority date, is your place in line. 22nd January 4th May 2006 is your priority date, meaning that's when your sibling, which is a 4 category, your sibling who's a US citizen, petitioned for you to get an immigrant visa. Once your case is approved, you have to wait, number 1, for visa availability. That's when you use a visa bulletin. You look for, let me go to the August visa bulletin. Guys, every month, the Department of State will release a visa bulletin, and it shows you how they are processing cases, whether there's visa, there's retrogression or there is progression. There's retrogression when there's more visa applicants than visas available, and there is progression when there's more visas available than visa applicants. So the visa bulletin will progress when there's more visas available than applicants. And then for retrogression, again, when there's more applicants than visas. So small visas, many people, then it retrogresses because it goes back. When you go to August 2025 visa bulletin, they're currently processing F4 cases that have priority dates before January 1st, 2008. So guys, there is a how many years of backlog? So 2, 10, 17, about 17, minimum 17 years if your sister or your brother who's a US citizen petitions for you under the F4 category. Okay, so it depends on the country you're in, your country of chargeability, China, India, Mexico, Philippines. For Mexico, the backlog is even worse. It's 2001. The priority date is 15th March 2001 for F4 category. So that's for 24 years of backlog. If you are being filed for in the F4 category, your brother or your sister who's a US citizen is petitioning or filing for you. The backlogs are insane. So feel free to contact us and we can take a look and assist you some more. AK Poku Law, feel free to Google us, or our phone number should be on our bio page. Okay. All right, let me see if we have any. Guys, drop me USA, please drop USA for me if you can see me, hear me good, and you are enjoying the session so far. Let's see if we can answer a couple more questions. Sorry, let me see if there's something on TikTok. Okay, Queen P on TikTok says, lawyer, please, my son's case has become approved and sent to NVC. When will I hear from them, please? All right, so again, we were talking about the preference immigrants category. Preference immigrants category, I'll tell you, we have 4 categories. Okay, we have F1, which is the unmarried son or daughter, adult of a US citizen. F2A is for minor children of green card holders and spouses of green card holders or lawful permanent residents. F3 is for married children of US citizens, adult sons and daughters. Then F4 is siblings of US citizens. So if you are doing something called consular processing, it means that the beneficiary, the person that has to benefit from the filing of the US citizen or the green card holder, is based outside the US. Okay, so number 1, we have a petitioner who's a US citizen or a green card holder under the family based or even employment based. and the petitioner has filed an immigrant visa petition, and they have to be given one of the categories. Depending on the category you're in, that's when we can tell, how the case will progress. Number two, USCIS is the federal agency that will adjudicate your affirmative immigration application. They are based in the US. First part of the application goes with them. Second part, so the application is pretty much in three parts. Second part is the National Visa Center. USCIS will forward the approved petition to the National Visa Center. National Visa Center is a part of the Department of State or Bureau of Consular Affairs. I would say Bureau of Consular Affairs, and it acts as a middleman or liaison between USCIS and the US Embassy where your beneficiary is based. So National Visa Center will collect civil documents, financial documents, tax documents, police records, and then you pay fees, you become documentarily qualified. You join the second queue. First queue, priority date. Second queue is your date of documentary qualification. And if everything goes well, as you've joined the second queue, it depends on the numbers ahead of you who are DQ'd ahead of you and your visa availability, availability of visa for your category. So there's a lot of things we have to look at before I can tell you when they'll call you. If you set up a consult with us, we can review that and then give you a time range within which you should be expected to be called, okay? Because there's a lot more questions that we have to answer. We have Nana KB who says on TikTok, how long does it take to receive your ROP from the immigration court when it's been requested? So the ROP refers to record of proceedings. These days they have ECAS, the system where immigration courts are managing files of undocumented people who are being processed through the immigration court through the virtually. So EROP, electronic record of proceedings, is what they do depending on the court that you had your proceedings at. Usually, if you just recently had your record of your immigration court hearing, then they are able to send you your record of proceedings sometimes within less than 30 days, honestly. Yesterday, I was actually in immigration courts with a client. We had a case and the temperature is really hot. The temperature is really, really hot in immigration court. It's always important to get your record of proceedings, especially where your case has been denied. You have 30 days from the date of the decision of the immigration judge to try to file an appeal with the BIA or try to do a motion to reopen or motion to whatever you want to do. You usually have a period of 30 days and you have to file a timely response to that denied petition. Obviously, if your case is approved, you usually, you don't need your record of proceedings, but I recommend that you have it for the future because usually US citizenship is not granted in court. US citizenship, adjustment of status, they'll give you a green card and then later you will apply for naturalization with USCIS. So it's very helpful to have your record of proceedings so that your attorney can review your history. So usually it should take less than 30 days. And EROP or electronic record of proceedings, I would say is different from FOIA, Freedom of Information Act. These are the two ways that you can request your records from immigration court. In fact, when it comes to even your record of proceedings, we sometimes go to the immigration court where this happened, and then the clerk can send us. Sometimes they'll send it to us in the form of a disk, a CD drive, and we have to put it in a computer and download everything, the transcript of what happened in court, what the judge said, what you said, the testimony you gave. That's a fast way to get it. Going to the courthouse, asking the clerk, can I have this? Usually what we would do would be to email the court clerk and then sometimes say, okay, we're going there, and then we pick it up. Sometimes you can do the electronic record of proceedings where they email their proceedings to you. And sometimes you can do the FOIA. FOIA it takes a lot of time, sometimes 2 years, a year and a half. Because FOIA, Freedom of Information Act, again, you have the right to request from any federal agency that I want what the US government has on me. Can I have all my records as it pertains to me? And the government will have to go to, or the court, EOIR will go to their archives and pull up all your records. Sometimes some people have records dating back 2009, 2005. So it's stored in archives. They have to go pull it up. So depending on the complexity, the numbers of people that are ahead of you requesting their records, then you could get those records that you use. You can file a FOIA to any federal agency, USCIS, CBP, EOIR, depending on where your interaction has been. And that can, if you don't file number one, you don't file the FOIA properly, they will likely redact a lot of it. There's a strategy to doing everything, especially in law, especially during these times. So make sure you're working with an attorney, because Googling and YouTubing is not going to help you much. It can give you an idea, it can give you the type of questions maybe you can ask your attorney, but when it comes down to legal strategy, it is not just piecemeal and picking tips from online. That's not going to help you. A legal strategy has to be holistic. There has to be a holistic view of your entire U.S. immigration history within the context of the laws as they are situated currently. Okay, so having strategic legal counsel is irreplaceable during these times. AK Poku Law, we work with clients in all 50 states, and I'll tell you guys, have already met Attorney Beliana, who's one of the attorneys. She's on our website. You can look her up. We actually did a couple of live sessions last year, or one, I can't remember. She was working with the U.S. government during the first Trump administration. She was assistant chief counsel, has done over 3,000 deportation cases, has over 12 years of immigration experience, and she's one of the attorneys on our team. And so we strategize when we have a removal case or deportation case. You have great legal minds who are working on it. So don't hesitate to contact us, and we'll be happy to assist you with what's happening. There's a lot happening. You guys share this live feed. Share this live feed. There's so many people that are hiding in the shadows. They cannot tell you that they have immigration problems. But if you share it on your wall, in your stories, they might see it and they'll get the right legal help. So make sure you're sharing it, because there's somebody that needs to hear this information. Okay. Yeah. So you can save your family members, your friends, or your generation. All right. Nana Bebio says, can I travel internationally with a page speeding tickets, green card holder? We've addressed this multiple times. Please be sure to contact us before you do any international travel. If you have any issue, we can look into what's going on, and then we can give you proper legal advice as it pertains to you. All right, guys, I hope you've enjoyed this session. Make sure you're following AK Poku Law across all social media platforms. We are not relenting in our advocacy for immigrants. We're here to help you. We're here to serve you. We're here to fight for you. We don't back down until we have the results that we're looking for. You better believe that, because that's what's happening. We're trying to keep you updated. Also, make sure you're following our pages across social media, as I've already said. And hopefully, guys, I'm going to see you in our next live video session. Be sure to join us every Friday if our God in heaven gives us life, and if He permits, we will be here to assist you, answer questions, and discuss what's going on in U.S. immigration. All right, guys, take care. Have a wonderful weekend. I'll see you soon in our next live session. Bye.